welcome back to the Don and Gino Real Estate and Finance Show right here in your hometown station, AM 1220 KHTS.
And remember, our goal is always to guide you to personal and financial wellness. Well, welcome back to the Don and Gino Real Estate and Finance Show. We're on the second half of the show. I'm joined by Lisa Odom, a good friend of ours and a friend of the show's. How are you doing today, Lisa?
I'm great. How are you?
Good. She is with Poole, Shaffery, and she has done an amazing job for our team. And she's part of what we call our life team with America's Professional Resource Group, along with Chris Ingram, Lou Asbin, and the rest of the gang that you hear on the show all the time, helping us make sure that we can sleep at night and we have everything in order. And she was asking me today before she came in, what do you guys want to talk about? And I said, we still see a lot of mistakes and a lot of, being that the first half of the show was with Stephen DeVore, a real estate broker, telling you some of the pitfalls that real estate agents commit. Well, let's now get into some of the pitfalls that escrow companies and lenders commit when they don't advise you on how to take title. It is such an important part of the real estate transaction process, yet it's kind of treated very nonchalant and just not given a lot of importance. And escrow wants to say, I'm not legally licensed to tell you about it. And lenders say, I'm not legally licensed to tell you about it. You should call Lisa. And then they never call Lisa. And it's day 26 of escrow. And lo and behold, a vesting appears.
Right.
So tell us a little bit about a couple things. One is, what is title in California? What does that mean to us? And then what are the ways to hold it? And what are the pros and cons of some of those options?
Well, title is obviously the way in which we get to hold property. So that's the record that keeps our property ownership. So when you purchase a home, it appears on the chain of title, establishing that you own the home. And generally speaking, when you're in a purchase transaction, you get a title policy that also ensures that the title that you're getting is actually what you're getting. And that way, if for some reason the property you're getting isn't what you think you're getting, you actually can use insurance to try to get that sorted out.
So you mean things like, for example, the rights to the home, the mineral rights, or the size
Correct.
of the lot, or things of that nature?
Yeah, the size of the lot. The most common things we see when there is title issues usually has to do with easements or encroachments, where maybe someone built a block wall that went a little too far over. Sometimes driveways. There's a lot in Valencia. There's a lot of shared driveways.
I have one.
And
my house has a shared driveway. I'm on a flag lot.
Yes, and we have been embroiled in litigation before with shared driveways. There's a lot of unique issues that happen, and those are title issues that come up.
Like poor drainage?
Correct. Poor drainage, or also use of. Sometimes if you and your neighbor don't get along, there could be a fight over how the driveway is used, and that's what we see.
She's sweet as pie. I'm the bad behavior with the extra cars.
Well, I imagine that. So,
Yeah.
but so that's what title is used for. It's to establish what you own and how you own it. So there's 5 different ways that you can own property in California. There is obviously just sole ownership. Gino Franti, a married man, is a sole and separate property.
So I can't take, even though I'm married, I can take the property by myself.
You can.
But it's a community property state.
It's a community property state.
What does that mean?
Well, there's a myriad of issues that come up with spouses who, and there's a million reasons why it happens. Most commonly, I think I mentioned to you before we started today, I had a client who just came in, and when they did the financing, the lender told him that only he could be on title. So his wife wasn't on title. They were headed out of town. She realized it, and she was none too happy. And we had to add her to title as joint tenants. And of course, that's not really the effective estate planning approach, but at least it got us through the week of being away.
So let's pause right there for
Sure.
a second. This is an issue that's been going on for over a decade. I mean, as long as I've been in the business, 15 years, 16 years, I've known that this problem exists, is that lenders, realtors, and escrows are not the right people to tell you how to take property, how to take title to a property. And the worst misconception, because it's easy, is to say, if only the husband is going on the loan, let's have only the husband on title. If only the wife is on the loan, let's have only the wife on title.
Right.
Why? There's no reason for that. There's absolutely no reason for that. As a lender, I can tell you that Fannie, Freddie, FHA, VA, and most jumbo lenders don't mind if you take title with your spouse, as long as the debtor is the one on the note. So you sign 2 instruments that are super important when you get a loan.
Right.
The note and the deed. The note is classified as who owes the money, and the deed is who owns the property. So one person can own the debt, and 3 or 4 or 6 people can own the property. It doesn't matter as long as somebody holds the debt.
Right.
And that's the person that qualified for the mortgage. So don't think that whoever's on the mortgage has to be on title. I'm going to elaborate one more second on that.
Yeah.
The next element of that is you'll also hear the other wise tale that goes with that is that you can't be on the contract if you're not going to be on the loan.
Also
Again, not true. Okay, because anybody can be on the contract.
Totally.
And even the people on the contract don't necessarily need to be on title. They should, probably. Usually the one that's on contract is on title, but they're not necessarily on the loan.
Right. Usually the lender requires that.
But I think you don't have to be on title as well on that one. You can take that somewhere else if you need to. But most of the time, it's whoever's buying the home should be on the contract. Whoever's going to be owning the home should be on title. Whoever you want to be indebted for the home, that could be one of the two parties.
I mean, one of the cases that we had to litigate this last year actually involved this exact situation. For finance reasons, a spouse was left off. Her husband passed away, and it was a blended family situation.
Oh my God.
So there was children from a prior relationship. So the title said to the husband, as a married man, is his sole and separate property. Well, under the law, when you die without a will, the intestacy scheme runs differently if it's sole and separate property versus community property. So we took the position that it was all community property. And the reason for this is that presumptively in California, all property acquired by a married person during the marriage, absent an express agreement to the contrary, is community property. However,
and the deed is not an express contract?
Well, so here's the issue. The deed, that usually a spouse is required to sign a deed explaining that she understands that it was a sole and separate property transaction, and that was something that the lender required, and these are very common. I see them all the time.
Horrible.
And turns out we actually prevailed on this. It was community property, but not until we went into battle with the adult child of the deceased husband. And it ended up costing our client quite a bit of money in costs related to the litigation.
More
time.
than $3,000?
Oh, way more than $3,000.
Okay, so because we're going to get here, we're with Lisa Odom at Poole Shaffery, and we're going to get to the point here where we talk about the ultimate way to hold title, right? So we've now talked about individual.
Right.
We touched a little bit on joint tenancy. Tell us what that's like.
So joint tenancy is when you own, so you and I could own a parcel of property and it would be as joint tenants.
We don't have to be married? Can we be joint tenants anyway?
Yeah, anybody. Okay. We're not married and we can own it together.
Okay.
So we take it as joint tenants, but what that means is that, let's say I passed away, 100% of the property flows to you. Well, if the reason we own this property together was because we were business partners, my family has now lost my investment in this property. And also, it's an equal ownership. It's 50-50. Like, it's not, whereas if you own it as tenants in common, let's say I made a 30% investment and you made a 70% investment, you can actually have the proper percentage allocated to you. So joint tenancy it can be great for a married couple if only one spouse dies. Of course, if both spouses dies, we have a probate problem. But with joint tenancy, 100% is automatically going to the survivor, whether they're family, whether they're not, doesn't matter.
Yeah, definitely not the right way to go if it's a business partnership.
Correct. So tenancy in common would be the next way of handling that. And like I said, it's good because at least it reflects your accurate ownership interest, and it does not automatically pass to the other owner. The problem with tenancy in common, of course, is you and I are partners. I die. I don't have a trust, which is obviously not true. I do. But now my property has to be probated. Well, what if it's in the middle of a sale? You can't sell it because the house has to first be probated. So it creates a whole myriad of issues too. It's not necessarily the better option.
So individual, fine, potentially. Joint tenants, proceed with caution. Might be okay for a married couple, probably not great for partners. Tenants in common, pretty good for partners, as long as both partners have wills and trusts.
And live. Yeah. Well, or they live. If they don't have a trust, they just live.
Okay. Or live. You could live. Yeah. That's a good option. I think everybody would choose to live.
Just stay alive. Exactly.
But again, we're talking about the reasons people would, how they would protect themselves should they die, really, is what it is, unfortunately. And we have a couple of more things to get to, and then we'll get to the ultimate way to hold title.
Right.
Or what I believe to be the ultimate way to hold title when we get back to the Don and Gino Real Estate and Finance Show this Saturday morning.